Good day, Mom and classmates. We are Group 6 Reporter number 8. So for today, we are going to discuss our report in Seeker 103, Module 2, Lesson 4, entitled Pardon, Amnesty, Commutation of Sentence, and Reprieve. So I am the first reporter, and my name is Lea May Carino. So first, we have the power vested to the President of the Philippines under the current 1987 Constitution. It gives the President the ability to grant executive clemency at any time and under any circumstances. So here are the partial list of people pardoned or granted clemency by the President of the Philippines. So the individual pardoned by Josep E. Laurel is Feliciano Lizardo, who is an assassin who attempted to take the life of Laurel at the Wakwak Golf Course in 1943. And the individual who pardoned by Ferdinand Marcos is Hiroo Onoda, an imperial Japanese soldier who remained in hiding in the Philippines even after the official end of World War II. So he was pardoned for actions against local residents in Lubang Island. And these are the individuals pardoned by Fidel V. Ramos. Number 1 is Robin Padilla. He was convicted for illegal possession of firearms in 1994. So he was granted conditional pardon from April 1997 to 2003. Next is Jamie Tadeo, kilusang magbubukid ng Pilipinas leader, charged of swindling during the martial law era under the President Ferdinand Marcos. So he was granted absolute pardon by Ramos in 1998. Joseph Estrada was pardoned by Gloria Macapagal Arroyo also. So he is an Arroyo's predecessor, deposed in the Second EDSA Revolution in 2001. He was convicted of plunder and he was granted pardon in 2007. And under Benigno Aquino III, the individuals who were pardoned are Antonio Trillanes, Danilo Tin, and Renato Miranda. So they lead figures of the Oakwood Mutiny against the administration of President Gloria Macapagal Arroyo in 2003. And our former President Rodrigo Duterte also pardoned these following individuals. We have Robin Padilla, who was convicted for illegal possession of firearms in 1994 and was granted absolute pardon in 2016. The second one is Jovito Lameras Jr., who was first elected governor of Antique, convicted for graft. He was granted conditional pardon in 2016 if he pays the Antique Provisional Government about 2.65 million. And we have Joseph Scott Pemberton, American military personnel convicted for the homicide of transgender women Jennifer Laude in 2014, granted absolute pardon in 2020. Now, let's proceed to the definition of pardon. So what is pardon? A pardon exempts a convicted individuals from any remaining punishment or future consequences stemming from a conviction. So, a convict is allowed to be freed from prison before he could finish his sentence given by the President of the Philippines. Next is the commutation of sentence. So, commutations reduce an individual's sentence either fully or partially. So, it's the reduction of sentence upon application by the inmate and approval, of course, by the President. We also have another definition for pardon. So, pardon is to release a person from further punishment for a crime. The definition of pardon is an official document freeing someone from additional punishment for a crime committed. For example, President Ford releasing former President Nixon from penalty for his participation in the Watergate scandal. Next is executive clemency. But before we tackle what is executive clemency, first, let's define what is clemency. So, clemency simply means leniency or mercy. It is considered to be an act of grace, and it is also not a right, but rather a privilege. So now, what is executive clemency? So in the United States, executive clemency refers to the general powers of the president and of governors to pardon, grant amnesty, commutation of sentence, or reprieve to individuals who have either been convicted of or may face the prospect of conviction for a criminal offense. Now, let's proceed to the extinction of criminal liability. So, the criminal liability of the person is extinguished into two instances: the partial and total extinction of the criminal liability of the convicted felon. So, in partial extinction, it means that there remains liability, although it is lessened by conditional pardon, commutation of sentence, and for conduct earned by the offender while serving his sentence. And in total extinction, it means that the entire penalty is extinguished and there is no more criminal liability. Now, let's talk about the 5 total extinction of criminal liability. So the first one is by marriage of the offended women. Second one is by the death of the convict as to the personal penalties, and as to precautionary penalties, liability thereof is extinguished only when the death of the offender occurs before final judgment. The third is by service of sentence. The fourth is by amnesty, which completely extinguishes the penalty and all its effects. And the fifth is by absolute pardon. Now, I will explain those 5. So, the first one is by marriage of the offended women. So, it says that marriage of the offender with the offended women after the commission on any of the crimes of rape, seduction, abduction, or acts of lasciviousness must be contracted by the offender in good faith. So the marriage contracted only to avoid criminal liability is devoid or has no legal effects, and that the criminal liability of the offender is not extinguished. So ang sinasabi dito sa number 1 is that, for example, in case of rape, ngayon, yung offender, inalok niya si babae, the offended party, na pakasalan na lang ito. Or panagutan ang nagawa niyang pang-rape doon sa babae. Ngayon, pag yung offended party nag-agree doon na pumapasok tong number 1 dahil mawawala na yung criminal liability. Kasi papakasalan niya na itong babae and mawawala ng visa yung criminal liability niya. And the second one is by the death of the convict as to the personal penalties, and as to the pecuniary penalties, liability thereof is extinguished only when the death of the offender occurs before final judgment. If the offender died before final judgment, its pecuniary or civil liabilities is extinguished. But if the convict died after final judgment, the pecuniary penalties or civil liabilities is not extinguished. If the offended party died, it does not extinguish the civil and criminal liability of the offender due to the reason that the offense is committed against the state. So, ang sinasabi dito sa number 2 is that pag yung offender is namatay before final judgment, ngayon, ma-extinguish yung civil and criminal liability niya. And pag yung offender is namatay after final judgment, meaning meron ng decision yung korte, ngayon, ang ma-extinguish lang is yung criminal liability niya. Dahil nga wala nang mananagot doon kasi patay na yung offender. Ngayon, ang hindi lang may extinguish is yung civil liability niya, which is babayaran niya yun. Paano ngayon babayaran nung namatay na offender? Sa pamamagitan ng mga natitirang ari-arihan niya or sa babayaran ng pamilya niya. Next is number 3, by service of sentence. Crime is debt by the offender as a consequence of his wrongful act, and the penalty is the amount of his debt. When the payment is made, the debt is extinguished after the convict has served its sentence. Its criminal liability is extinguished but does not include the civil liability. So, after ma-serve or matapos nung convict yung sentence niya, mawawala na yung criminal liability niya. But, pag hindi niya pa binayaran yung daños perjuicio niya or what we call the civil liability, ay hindi siya ma-extinguish and hindi exempted ang civil liability niya. So, kailangan niya pa itong bayaran. Now, let's talk about number 4, by amnesty, which completely extinguishes the penalty and all its effect. So, amnesty is defined as an act of the sovereign power granting oblivion or a general pardon for a past offense, and is rarely, if ever, exercised in favor of a single individual and is exerted on behalf of certain classes of persons who are subject to trial but have yet been convicted. However, amnesty may be granted after conviction. So all its civil liabilities are being extinguished also. So ang amnesty is binibigay siya sa group of person who commits crime, especially that is a political crime. So it is granted by the chief executive and also with the concurrence of Congress. So it will wipe away all the criminal liability and its effects. So once na amnesty is granted, the criminal liability and civil liability will be extinguished. The last one we have by absolute pardon. So absolute pardon defined as an act of grace proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment the law inflicts for the crime he has committed. So, pardon will only extinguish the punishment of crime upon acceptance of the grantee. Once pardon is accepted by the grantee, the pardon already delivered cannot be revoked by the authority which granted pardon. Ang absolute pardon po kasi is once it was granted to a person, it will extinguish all the criminal liability as if no crime committed. So, parang walang nangyari. Kasi nga, for absolute pardon, there is no conditions na ibibigay ng ating president. Furthermore, mare-restore lahat ng civil and political rights like what happened to Robin Padilla. He was pardoned by our former president, Rodrigo Duterte.
Now I will discuss the two kinds of pardons. The first pardon is the absolute pardon. It is an act grace proceeding from power entrusted with the execution of the laws, which exempt the individual on whom it is bestowed from the punishment the law inflict for the crime he has committed, is one which is given without any condition attached to it. And these are examples of absolute pardon. Absolute pardon is when President Gerald Ford granted an absolute pardon to former President Richard Nixon on September 8, 1974. This pardon was issued for any crimes Nixon may have committed during his time in office, effectively absolving him of any legal consequence. These are the effects of absolute pardon. Absolute pardon does not work to restore the right to hold public office or the right to suffrage, unless such rights are expressly restored by the terms of pardon. A pardon does not exempt the offender from the payment of civil indemnity imposed upon him by sentence. Absolute pardon totally extinguishes the criminal liability but not the right of the offended party to enforce the civil liability against the offender. Removes all that is left of the consequence of conviction, and that is absolute is insofar it restored the pardonee to full civil and political rights, like Cristobal versus Labrador. An absolute pardon not only blots out the crime but removes all disabilities resulting from the conviction, and that when granted after the term of imprisonment has expired, absolute pardon removes all the left is of the consequence of conviction. The difference between amnesty and pardon. So from there, amnesty and pardon are both legal concepts that involve forgiving or excusing someone for their action, but they have some key difference. Amnesty is a broad forgiveness granted to a group of people for offenses they have committed. It is usually granted by a government or an authority to promote reconciliation or resolve conflicts. Amnesty aims to provide a fresh start and wipe the slate clean for a large number of individuals who may have engaged in illegal activities. It is often used in situations of political unrest or when new government takes power. On the other hand, a pardon is a specific forgiveness granted to individual for a particular offense or set of offense they have committed. It is typically granted by an executive authority, such as president or a governor, and it absolves the person from legal consequence for those specific crimes. Pardons are usually given based on factors such as remorse, rehabilitation, or other compelling reason. In summary, amnesty is a general forgiveness granted to a group of people, while a pardon is a specific forgiveness granted to an individual for particular offense they have committed. Limitation of the pardoning power. The power of the chief executive to grant pardon is limited to the following. Pardon cannot be extended to cases of impeachment from Article 7, Section 10, Paragraph 2, Constitution of the Philippines. And no pardon, parole, or suspension of sentence for the violation of any election law may be granted without favorable recommendation of the Commission of Elections. Article 10, Section 2, Paragraph 2, Constitution of the Philippines. Pardon is exercised only after conviction. The next pardon is a conditional pardon. Conditional pardon serves the purposes of releasing through executive clemency a prisoner who is already reformed, rehabilitated, but who cannot be paroled because the parole law does not apply to him. Thus, a prisoner serving a determinate sentence or life imprisonment is excluded from benefit of the parole law. An example of conditional pardon is when an individual convicted of a non-violent drug offenses is granted a conditional pardon. The condition of the pardon may include completing a drug treatment program, regularly attending support group meetings, and maintaining a clean record for a specified period of time. If the person successfully fulfills this condition, they can avoid serving their full sentence or having a criminal record. However, if they fail to meet the conditions, the pardon may be revoked and they may face the original consequence of their conviction. Criminal liability is extinguished partially by commutation of sentence. Is an act of clemency by which an execute act changes a heavier sentence to a less serious one or a longer term to a shorter term. How conditional pardon given may be commenced by a petition filed by the prisoner, his family or relative, or upon the recommendation of the prison authorities. The petition of request is processed by the Board of Pardons and Parole. The board shall determine if the prison has served a sufficient portion of the sentence. His release is not inimical to the interests of community and that there is likelihood that the offender will not become a public charge and will not recidivate in the crime. If all these factors are favorable, then the board will endorse the petition favorably to the President. If the case is premature, the petitioner if is not informed. In determining the fitness of a prisoner for release on a conditional pardon, the following points shall be considered as guide. So these are the some guides in pardon selection. Number 1, the political, organizational, or religious affiliation of the prisoner should be disregarded. Number 2, due but not undue regard should be given the attitude of the people in the community from which he was sentenced. Number 3, the judicial history of the case should be carefully investigated. Number 4, the background of the prisoner before he was committed. Partial extinction of criminal liability. By conditional pardon, a conditional pardon delivered and accepted is considered a contract between the sovereign power of the executive and the convict that the former will be released later upon compliance with the condition. And by commutation of sentence, it is a change of decision of the court made by the chief executive by reducing the degree of the penalty inflicted upon the convict or by decreasing the length of the imprisonment or the amount of the fine. Commutation of sentence is an act of clemency by which an execute change a heavier sentence to a less serious one or a longer term to a shorter term. Is a reduction in sentence. In a commutation of sentence, a person is not absolved from a conviction completely, but his or her punishment is substituted with the lesser punishment. So, from there, commutation of sentence is a legal term that refers to an act of clemency or mercy by which an authority, typically an executive branch of government, changes a heavier or longer prison sentence into a less serious or shorter one. It is a form of reduction in the punishment that an individual is serving for their conviction. Purposes of commutation of sentence. A. To break the rigidity of the law. B. To extend parole in case where the parole law does not apply. C. To save the life of person sentenced to death. Instance where commutation is provided by law. Number 1. When the convict who is sentenced to death is over 70 years of age. 2 is when the justice of the Supreme Court failed to reach a decision of the formation of the death penalty. In either case, the degree of penalty is reduced from death to reclusion perpetua. In commutation of sentence, consent of the offender is not necessary. The public welfare, not his consent, determines what shall be done.
Hello everyone, now I will discuss the special time allowance. Special time allowance for loyalty. A deduction of 1/5 of the period of his sentence shall be granted to any person who, having evaded his preventive imprisonment or the service in his sentence, under the circumstances mentioned to Article 158 of this code, gives himself up to the authorities within 48 hours following the issuance of the proclamation announcing the passing away of the calamity or catastrophe referred to its said article. For example, Carlo was imprisoned and sentenced to 10 years, and there was a typhoon that caused the destruction of his prison, and he left it. And if he returns before 2 days after the calamity, he will be granted 1/5 or 20% deduction to his sentence, and he will only serve 7 years from his sentence. And a deduction of 2/5 of the period of his sentence shall be granted in case said prisoner choose to stay in the place of his confinement, notwithstanding the existence of a calamity or catastrophe enumerated in Article 158 of this code. For example, Carlo was imprisoned and sentenced to 10 years, and there was a typhoon that caused of destruction of his prison, and he didn't left, but he stayed. He will be deducted 2/5 of his sentence. And this article shall be applied to any prisoner, whether undergoing preventive imprisonment or serving a sentence. Now, who is the authority who will grant it? Director of the Bureau of Corrections, the Chief of the Bureau of Jail Management and Penology, and or the Warden of the provincial, district, municipal, or city jail shall grant allowance for good conduct. Such allowance once granted shall not be revoked. Good conduct time deduction. Conditional release is the statutory shortening of the maximum sentence the prisoner served because of good behavior while in prison. This is called good conduct time and is given by the law as motivation for good behavior while serving sentence. Article 97 of the Revised Penal Code provides good conduct time allowance to all sentenced under the following schedules. Number 1. Good conduct time allowance is automatically applied to reduce the sentence but may be taken away from the prisoner if he fails to obey the rules and regulations of the prison. Number 2. If the prisoner does not forfeit his statutory good conduct time allowance through misbehavior, he is released at time earned. He is released under supervision as if on parole and subjected to all parole conditions, which, if violated, will result in the issuance of a warrant, revocation of his release, and the requirement that he return to prison to serve the maximum term. This form of conditional release is used in federal, Kentucky, Kansas, North Carolina, and Wisconsin correctional institutions. The release of the prisoner is mandatory when the accumulated time deducted from the sentence for good behavior and work credits make it mandatory to release the prisoner. The Board of Parole does not participate in the selection process. This form of release, thus, whoever enabled the parole staff to provide supervision for a period of time by which his release has been advanced for good behavior as though the offender was on parole. The released prisoners are subject to the regulation and control of parole. In the Philippines, the prisoner who is released from prison after serving his sentence less the good conduct time allowance is released without any condition and is considered to have served his sentence in full. Article number 2489, otherwise known as the Industrial Good Time Law, provides that when a prisoner has been classified as trustee or penal colonist, he is given an additional 5 days time allowance for every month of service. A prisoner serving life sentence has his sentence automatically reduced to 30 days of imprisonment upon attaining the classification of trustee or penal colonist. When the sentence of death penalty is confirmed by the Supreme Court, the condemned man or the head of the prison system, director of prisons, may file a petition for commutation. Number 1. The prisoner is subjected to a social, psychological, or psychiatric examination by the staff of the reception center. Number 2. The petition is when forwarded to the Board of Pardons and Parole together with the reports of examinations of the reception and diagnostic center and the recommendation of the director of prison on the petition. Number 3. The Board of Pardons and Parole processes the petition and will deliberate on the recommendation after a careful study of the papers, including the reports of the reception and diagnostic center. It will then forward the petition, including its recommendation, to the President. And last, the President will then act on the petition in giving or denying commutation. The President may not follow the recommendation of the Board of Pardons and Parole.
Condition of pardon. First is that he shall live in his parole residence and shall not change his residence during the period of his parole without first obtaining the consent of Board, Pardons, and Parole. It says that pardonee and parolee doesn't have the privilege to change his residence unless otherwise there have prior approval coming from the BPP. Second, if the parolee and pardonee leaves the parole jurisdiction temporarily, he needs not get the permission of the board, although he may so inform his parole officer, municipal judge, of his whereabout. It says that if the parolee and pardonee leaves his residence temporarily, an approval from the BPP is not necessary, and information of where is all about is already sufficient. Third, that he shall report to the municipal judge of the town where he will reside, or to such officer as may be designated by the executive officer of the Board of Pardons and Parole during the first once a month, and thereafter once every 2 months, or often as he may be required by said officer. It says that with the approval of parolee and pardonee, he is required to report at least once a month, 4 years, and at least once in 2 months in succeeding years. Fourth, that he shall not indulge in any injurious or vicious habits, and shall avoid places or persons of disreputable or harmful character. It says that he shall not go to any houses in ill repute, such as gambling house or bars. 5. That he shall permit the provincial commander, Philippine Constabulary, or any officer designated by the executive officer of the board to visit him at reasonable times at his place of abode or elsewhere, and shall truthfully answer any reasonable inquiries concerning conduct or conditions. It says that he shall allow to any designated authority to visit here in his house. Number 6, that he shall not commit any crime and shall conduct himself in an orderly manner. I do not explain that because it is awatable naman. Number 7, that he shall pay not less than 50 a month to the cashier of the Department of Justice in payment of the indemnity imposed to him. It says that the parolee and pardonee shall pay at least 50 pesos. And last, shall comply with such order as the board or its executive officer may from time to time make. Okay, the second title that I discussed is Abuse of the Pardon Power and its Safeguard. The power vested on the President by the Constitution to grant pardon is very broad and exclusive. It is not subject to review by the courts. Neither does the Congress have the right to establish conditions nor provide procedure for the exercise of pardon. Under these circumstances, it is therefore possible that unscrupulous chief executive can abuse his power. In fact, nearly every presidential election, the alleged abuse of the pardoning has come up as campaign issued against the incumbent president. The truth of the charge has never been investigated, but the fact that this alleged anomaly is aired publicly is an indication that the power to grant pardon may be issued. It says that the power of the president is innate and exclusive due to his position, and because of this, no interjection from the court nor Congress can interfere with how the president will grant it. First is the constitutional provision that the president may be impeached for willful violation of a constitution. It says that there are provisions in the Philippines Constitution that the President shall follow while granting pardon. Second is the policy of the Office of the Chief Executive ever since the time of the American governors general to approve pardons cases which are favorably recommended by the Board of Pardons and Parole. Although this policy does not fully bind the President, seldom if ever has it been disregarded. It says that in general in favorable recommendation the coming from the BPP shall be furnished first before the grant of pardon, but this process is not binding to the President, and because of this, he cannot grant pardon based on his sole discretion. So, is pardon necessary in our penal system? Injustice may result. An innocent man may not able to present evidence to prove he's innocent or may not have the money to hire a good counsel. And because not all prisoners are qualified for parole, conditional pardon is therefore necessary. Many of our penal laws are outmoded and are no longer kept abreast with current trends of criminal justice administration. Judges are limited by laws to the use of discretion they may exercise in any given case. Only be remedied by the exercise of pardon which injustice resulted. Society can only be sufficiently protected against the ex-prisoner if the latter is released through parole or conditional pardon. Note, not all sentences are indeterminate so that some prisoners are deprived of the privilege of parole. Pardon is necessary for the prisoners who do not fall under the parole law. So next is amnesty. First is a general pardon extended to groups of persons and is generally exercised by the executive clemency with the concurrence of Congress. Okay. Amnesty is an executive clemency granted by the President with the favorable vote of the Congress. It looks backward and abolishes and puts into oblivion the offense itself. It overlooks and obliterates the offense with which he is charged, that the person released by amnesty stands before the law as though he had committed no offense. It says that it permanently deleted or eradicated the charge against them. The purpose of amnesty. The purpose of amnesty is to bring about the return of dissidents and recalcitrant elements of our population to their homes and the resumption by them of their lawful pursuits or occupations as a loyal and law-abiding citizen, to accelerate the rehabilitation of the devastated country, restore peace and order, and secure the welfare and happiness of the communities. People versus Santos. It says that amnesty is granted for the offender to continue of way of living. So these are issued proclamation by the President for the grant of amnesty. First is Proclamation number 51. This proclamation was issued by the late President Manuel Rojas on January 28, 1948, granting amnesty to those who have collaborated with the enemy during World War II. Second is Proclamation number 76. This was issued by the Presidents Elpidio Quirino on June 21, 1948, extending amnesty to leaders or the Hukbulahap and Pambansang Kaisahan ng mga Magbubukid, PKM. The amnesty applied to crimes of rebellion, sedition, illegal association, assault, resistance, and disobedience to person in authority, and illegal possession of firearms. And last but not the least, the Proclamation number 51 was issued in order to attain the following objectives: to pardon those committed crimes and against security of the state who have changed their hostile attitude towards the government and have voluntarily surrendered with their firearms and ammunition, to get the dissidents back into the fold of law-abiding citizens, to gather the loose firearms.